Actually, she was asked about that. Judge Jackson was asked about affirmative action, and she said that she would recuse herself from this case. So if she recuses herself, can she be a part of any of those conversations to lend that experience that you're talking about?
So here's the rub of this. Like, it is true that she has served on the Harvard Board of Overseers, which perhaps may provide a foundation for her removing herself from the consideration of the Harvard case. But there are actually two challenges, Jonathan. One, a
Ah,
statutory challenge rooted in Harvard's practices, but also a constitutional challenge about the University of North Carolina. And arguably, that constitutional challenge is perhaps the bigger case because it will determine the constitutional status of affirmative action. And she's not precluded from recusing herself. She's not required to recuse herself or even suggesting to recuse herself in that case because she has no dealings with the University of North Carolina. So she can certainly participate in that case. And there was a couple of terms ago a case regarding faithless electors, and Justice Sotomayor removed herself from one of the cases. There were two cases at issue because she knew one of the litigants, but she participated fully in the disposition of the other case. And you could imagine a similar kind of dynamic happening here in the context of affirmative action. So I think this is why we didn't get that much discussion of it at the confirmation hearings. I think Republicans were set to make a big deal of it, but there are these two cases. And if we're going to talk about recusal politics, we probably also want to talk about the Thomases. So maybe that was a reason to not talk about it at all.